I'm just going to run you through in regards to the signing of the interlocutory application to set aside judgment with this case for New Zealand Police. I went to the High Court and I was served at the counter by a young guy named Dan, and then later on he got the case officer Sharik Ali to serve me at the counter. Now, I wanted to go in there and I wanted to once again have a one-on-one consultation with the case officer, Deputy Registrar, in regards to the signing of the set-aside judgment interlocutory application, because this has been an ongoing issue with the other cases. But this time I went there and I took the laws with me, and because I just wanted to skip all the middleman and I wanted it to be signed and for it to go to the judge. Sat down with him and I was prepared, and we had this discussion because I had found with the other cases the deputy registrars or the people at the counter, they're not really fully informed. Either they're new or they're inexperienced and are not intellectually able to actually really interpret the laws on the documents, because that's not their job. That's why we have judges. So what actually happened was, this time I sat down and I just wanted to prove to the court registrar or the deputy registrar that the laws that actually back up everything that I'm saying. And I showed the actual laws that supports the judge, that actually gives the judge the authority to enforce an order, because that's what I wanted. This is what the usual procedure was before I actually switched to this new age system. So I'll just quickly run through the old system. The reason why they did this was because it cuts down the court time. I mean, obviously I'm the victim, and they've done wrong to me. I haven't done wrong to them. It meant that once it's enforced, it goes before a judge. The judge can actually make an order on papers. If I can satisfy the judge that there is sufficient evidence to prove that there has been a miscarriage of justice, and then that's the end of that. And that's exactly what I wanted. There hasn't gotten to that stage in any of my other interlocutory application, except one. I think PSA is, but the other one is a judgment of liability already signed, but that's just still sitting in court at the moment. So this new age system, I have found that they've changed it where now it's the registrar seems to have a little bit more authority now with handling the civil cases in regards, to the case. Skip the middleman and it'll go straight to judge. That's the usual procedure that I'm used to. I've had, issues or problems where the registrar hasn't understood where I was coming from because of lack of experience and knowledge. That is what I have actually found during the process of my cases. So on this particular day, I took the supporting laws to convince and to talk to the registrar. I mean, I did everything to the letter as far as I knew that there was sufficient evidence or, enough to satisfy the judge to make an order. Another thing is, if you're going to sign something like that, you have to be 100% that nothing of it is fraud or it's going to backfire on you, because they will investigate every single thing that you put before a judge to sign. But I was confident that was the best route for mine. I felt that I know without a shadow of doubt that New Zealand Police couldn't contest it, Crown couldn't contest it. So what actually happened at the counter when it comes to the administration of the law, they're supposed to understand why these applications are for. So it was a little bit frustrating for me because this has been an ongoing issue, and I have felt that the courts was siding with the defendant, and I was outnumbered. I felt it. I felt that they were siding with the defendant. I've even complied and have gone through the submission with the registering, with the complying with the legal documents as far as the scheduling is concerned, but that was okay by the judge. And I have found that the defendant's application, I just found a lot of errors in their application and in their submission. I was able to actually challenge it and prove it legally and oppose all the laws and all their submissions. So it's been quite inhumane for me because I know what I'm talking about, only to have it sabotaged. And that's what's actually happened. So what happened on this particular day, I clearly showed to the registrar the law as far as the interlocutory application and the affidavit, because the law clearly says that one can't go without the other. Then you take that. Then I took in the laws that supports the judge to actually sign it. It clearly says that judge has to do it. It's not a registrar's job, or the judge actually has to do it. I wanted him to agree to sign the interlocutory application and the exhibits. That wasn't really like I had to take it home and then come back the next day and get them sworn. So at the end of that conversation, I felt we were on the same boat, and he couldn't really contest anything I was saying because everything I was saying was true. Oh, there was just part of our conversation. He made it clear to me, I found it the reason why they were doing what they're doing was because I didn't have a law degree. As you can see, this here is the Ministry of Justice website. I just wanted to go over the part about representing yourself in court. Just looking at the moment, if you can see, representing yourself in a civil case in the High Court. You can do it also in the District Court. So my case did start from the District Court, and then it went to the High Court, and then it's also gone through. This is the Ministry of Health and City Med case. It went to the Court of Appeals, and it also went to the Supreme Court, and then I took it back to the High Court under judiciary review. So I just wanted to quickly just go over just confirmation. This is the actual website of the Ministry of Justice that clearly says that you can represent yourself. So they've done a few changes here, but I can confirm that the laws do confirm you can represent yourself. Now, the reason why I felt it was relevant for me to show you this, there's nothing in there that says that you have to have a law degree. Now, the reason why I am entitled to represent myself, because my personal property, which is my profile with all the agencies, like for example, my employment records, medical records, anything that you're a client to, even your bills and stuff like that, that is your personal property. Even with the landlord, all that is your personal property according to the laws. Now, If you are a corporate body, business, say you own a business or an organization, that is your asset. And yes, the laws do allow you to actually represent your business. Okay, but what you need to do is you have to be actually confident in what you're doing. The way the court process is done, it's very technical, and the language has to be accurate. What you perform to the courts, the format of the court and the laws and the language is completely different. So you need, all that goes through a process before it's actually even granted. So, but the laws do allow that here in New Zealand. And I just wanted to focus on my case and just go through what gives me the right to take my case and to represent myself in the courts even today. Okay, so I'm going to keep this short. So what I'm focusing right now, I'm going to go back to the judiciary review application. Okay, because all my statements of claim all reflect, like with every other corporate bodies, are all under the statement of claim here that's under judiciary review. This here, like every single corporate body that's mentioned in this judiciary review, that was done against the Ministry of Health and City Med, and I added all the corporate bodies in this judiciary review, which makes them all active because it's all my profile. Everything about my case is everything about the incidents that occurred during my existence while working for my employer and while I existed on Earth. So what I'm going to quickly just go over my case is the law that actually allowed me to represent, or evidence to prove to the court that I am able to represent myself against the Crown and as an individual. So here it is here. I've noticed that they did delete it. It's not there anymore. But however, during this time when I actually used I actually put my statement and my notice of proceeding together, these laws were actually active, as you can see right here. Just this law here where it says the District Court Rule 1947, this is the legislation for that actually allows me as the plaintiff, or the one that is suing the corporate body. This law here clearly says that I'm able to represent myself and act personally. Okay, all the other options I had at this point in time, going back to 2016, since 4th of July 2016, this law actually covers everything to do with me representing myself in the court. So I also had the choice of having a barrister or solicitor of the High Court, but the law clearly says that no one else can represent me other than myself personally, unless I took the option of a barrister or a solicitor. Now, the other options that I would have had as an individual representing myself is the legal aid. There is a legal aid system available. The unfortunate thing is it's not available to anyone unless you are the defendant. So in this case, I am not the defendant, I am the plaintiff. However, it is still available to me for a legal aid to take over my case, but the judge has to make that ruling. But a judge can make a direction to have my case have that option whether I wanted to do legal aid, but I feel I'm competent enough to do my own. The law also allows me to prosecute the defendants in the criminal jurisdiction, which some of the cases will go down that route. But at this point in time, even though some of the laws are deleted, last time I looked, this law was no longer there. It's been repealed, and which means it's been deleted. And I said, well, you know that we are able to represent ourselves. I'm entitled to do that because the facts that I'm submitting to the court, it's about my real life incidents, my existence on earth. It's all about me. It's real and it's true. It's authentic. And I also made it clear it's my property. So it was quite clear that was another reason why they were, sabotage is the word, to be honest. Anyway, that kind of came in the conversation. We did end up being on the same boat after I walked them through with the laws, keeping in mind that there's also another law where a registrar is not allowed to actually decline signing a document, but they were refusing. I also said to him, because what I ended up doing was I put a memo together that was submitted on the 5th of July 2024 from the last episode. On that memo, I will go on that memo just to finish it off. This is my environment, okay? And this is an ongoing problem where I have applied for, the opposition knows my income. They know my bank account. They've literally watched me go down financially, historically, and I haven't been able to advance because the sabotage, like I'm literally pinned down sort of a situation. I've gone and applied for applications because I wanted to pay the fee and just to cut out, because I didn't want to use the waiver fee because the waiver fee process is involved, it's changed too. So I'll go through that about the waiver fee process. So I asked the case court registrar about how much does it cost, and apparently it's $600 for this application for the set aside judgment. Right, the fee used to be $90. It still is in the district court, and really that is still what it is, because they were saying because it's district, this is high court, but the whole file itself, even if it went before a district court judge, it has the same authority, the set aside judgment law in regards to that, even though it's on high court, it's on the district court rule too. The district court judge has the same authority to actually enforce that. But the fee is actually charged for $90. Now, the reason why it's $90 is because I know that they can't contest it, even if they tried. I was confident for it to go down that route. I can prove everything I'm saying, and because I know it happened. So basically, they've perverted the course of justice and all these other laws. There's been a definite a definite miscarriage of justice on their part. Okay, so the other reason why this law is also in place is quite obvious, because there's been a miscarriage of justice. Common sense is it means the liberty of the person is at stake. Crimes like this, things like this, it will only, if it's ignored like a breach, it will accumulate to even worse things. And that's exactly what's happened. It's definitely a duress set of circumstance from my point of view, and my set of circumstance during this point of time of trying to get, put a closure to all these things so I can go forward. Every case is different. There's no case that's exactly the same. My case is definitely very complex, and my case would class as a category 4 case in the criminal jurisdiction, and it is also a high priority case, which means on my case is quite clear. I'm the victim, and whatever happens to me affects everybody else in my private life. So that's why I was trying to use the protected disclosure, use the harassment order, because of the indirect criminal harassment and the way I've had to live. They, push me out of my job. So I asked the court registrar in regards to the waiver fee. Now we're going to go on to the waiver fee, and I said, because we had a bit of a dispute about him signing it in there, and then I said, well, I want to pay the fee. How much is it? He said it was $600, and I said, okay. Then he goes, oh, but we don't have to sign the interlocutory application. We only sign the affidavit. We don't sign the interlocutory application anymore. And I said, but, then I went through the whole scenario in regards, according to the lawyers, that I'm within my rights for them to do it. And then I said, well, what is the $600 for? Okay, because some of these applications, they can cost up to $1,500. And some of these applications can take months to put together, especially a case like mine. But these application costs from about, I think they can come from about $2,000 or $1,500. It kind of depends. It varies. So I said, so what is the fee for then? Why are we paying the fee for? Because my understanding and what I'm used to is the fee is actually to pay the judge to enforce the order. That's why we're paying the fee. And he said, oh, well, you're paying the fee, he said. You're paying the fee for the interlocutory application. And I says, yeah, but the interlocutory application is nothing without you guys signing it. The affidavit, the interlocutory application, and the affidavit of the documents that goes with it, without both of them being signed, all it's doing is that the interlocutory application is the power document. The foundation of the whole case, and the documents is in reference of the interlocutory application. And he said, well, we don't sign that anymore. I don't know how long they stopped doing that. That's what their process is at the moment. But I did make it clear to him, and I wasn't really happy about it, because I didn't feel right with that process, because I felt they were committing fraud. That's what I felt. According to the laws, that's what will look like. I said to him, well, the fee for this document is paid because it's for the judge to make the order. So it didn't make sense why we're paying the fee if the judge is not going to make an order. Without the deputy registrar signing it, the piece of paper has no power. It's just a normal piece of paper. At the end of all that conversation, he said he will sign it. So I was happy with that. So I had to go home, and then the next day I came back and he refused to sign it. And that is how it's been for me historically. I'm talking about the banks. I'm talking about anybody that I'm a client to. The opposition is in there either updating the information or declining or just making things very stressful for me. Nothing has been straightforward. The other subject I wanted to discuss with him was the waiver fee process. So I had some questions to ask in regards to this, because I have found they didn't have any concrete structure around this involving me. Okay, so I've used the waiver fee process a lot during my court cases. I have had an interlocutory application sworn and paid for in one of my cases in the past. And so what I had actually asked at this on with Sharek on the 3rd of July 2024, I just wanted to know what was the process for the waiver fee process. I wanted to know because I didn't want people reading my documents like all the other cases, because that's what's happened. I felt my documents was being deliberately being violated, and people were exploiting my file. Like I felt, I know I'm being exploited. And I felt they were treating my file the same, where heaps of people were getting a good gawk at my work, and that I was trying to, many times I've tried to stop that. So I asked about the waiver fee process, and I asked in regards to how does that application process go, because in the past they've actually sent the files out of court and sent it around. This is in the past, and I didn't want I didn't want anyone else reading my documents other than the case officer, because that's what I was trying to do. Is just but then I went through the process. You can't get the case officer. They don't ring back, or when you go there, they've left. They say they're not. You just can't. You end up talking to different people all the time, and they make up all kinds of excuses. But they're just excuses as part of the sabotage, because they know it's me. So on this particular day, I asked him the process of the waiver fee, and he said that the waiver fee process, somebody else actually grants it. So I said, okay, so what happens with that? Do they have all my file has to go for them to actually grant the waiver fee? I mean, it's just an application. All you have to do is prove that you're in hardship and that you fit that category to apply for a waiver fee on your documents for the judge to process. So I asked him, because I said to him, I just wanted to know, with the privacy of my documents, who handles the waiver fee, how does it process? Because I said the old process, a case officer handles everything, especially in high court matters, especially indictable cases, matters like mine. And I didn't want heaps of people reading my documents, because I felt they were all stealing my intellectual property. That's what I felt. That's what I feel that is what everyone has used me for. And if they're not doing that, they're retyping everything. I know when it's my work, and I've just, it's been inhumane. I'm just going to do just a quick clip on the penalties of organisations and any government agencies when they, have done very serious misconducts or very serious violent offences. This includes anyone in government organisation according to the laws, the penalties and the actual pecuniary penalties, it's called, and criminal liability. So a case like mine is a very serious case, of course, because there's a lot of very serious indictable criminal offences. So in hindsight, the case itself is worth a lot more money, but according to the laws, and I'm just going through this because I think this is really important to make sure that they don't get away with it. With my situation I've been representing myself legally in court since 2016, but the case has been sabotaged and turned into a monopoly game sort of a thing. So this is where I got the amount. This is not, it clearly says here, for an individual who commits an offence is liable to $500,000 fine, or both, which means they can get a conviction too. But it is a case-by-case basis. So individuals can actually get sued $500,000 and a conviction, or both. And over here it clearly says it's $10 million. Also for organisations, because organisations and corporate bodies are all treated as an individual. So this is where I got the $10 million for each organisation. So I thought I'd just put that up to make sure that they don't get away with it. But this is what is actually happening secretly behind the scene. I'm doing everything myself, so it's been frustrating. So when I go out, different people come out and they're playing games with my life when I'm by myself. It's dangerous, really. It's not acceptable for anyone to go through what I've gone through. But I don't know who's doing it. But the everything is staged, and they're staging people in my space when I do go out, just to go to the shops, and doing their indirect, whatever they want to call it,